Fantastic. Sarah Beardsley, subbing for Elizabeth Dickinson. Sarah will be joining us later. Neil Eisner. Andrew Emery.
Yep, here.
You. Cynthia Farina. Michael Hertz.
Yes, present.
Fantastic. Chris Henson as an alternate for Richard Hippolyte. Okay. Sally Katz. Okay. Katya Kuto. That's later. Daniel Lieben can't join. Hillary Malauer can't join. Jeremy Shaw, another engagement. Same with Randy May. Nina Mendelson. Lena Ness. Rebecca Orban. Thank you.
Yep, I'm here on behalf of Rebecca.
Perfect. Nicholas Perillo. He will be joining late. Richard Pierce. Okay. Nick Plave. David Pritzker.
Yes, I'm here.
Fantastic. Teresa Roseborough. Berto Ross can't make it. Helen Serratio or Andy Simon, who's an alternate. Okay. Go. Anna Shavers.
Here.
You. Lon Smith.
Here.
You. Kevin Stack.
Here.
Yep. Robert Stone or his alternate, David O'Connor.
David O'Connor here for Robert.
Fantastic. Tom Sussman.
Here.
Thank you. Miriam Vincent can't make it. And then Adam White, who I believe may be joining by phone.
Yep, here by phone.
Fantastic. All right. And then before we go to the if you're a committee member and you did not just hear me call your name.
Hi, this is Katya Curdle with FMC. I'm sorry, I was a little late.
Thanks, Katya.
And this is, sorry, I'm late. Dave Rosker for Charlie Maresca.
Fantastic. Thanks, Dave.
And this is Sarah Beardsley.
Thank you, Sarah.
Thanks.
Dan Prezel's here as well.
Excellent. All right, then in terms of non-committee members from ACUS, we have Boris Burstein.
Here.
You. Amy Bunk.
Here.
Bill Funk.
Here.
Bridget Dooley.
Hi.
Fantastic. Jeff Lubbers.
Here.
Fantastic. And I think that is everyone. Sorry, on that note, Kevin, I'll turn it over to you.
Great. Thanks, Mark. I'm going to turn first to Matt Wiener, but before I do so, many of us unmuted to say that we were here. So if you could just check to see that you're muted again so we can hear Matt clearly, that'd be great. Thanks so much. So over to you, Matt.
Thanks, Kevin. Very briefly, is Sally Gatson here, by the way, Mark? I saw her name on the list. I don't know.
The RSVP, yes, Sally, are you here? I didn't hear her RSVP or her speak up during attendance, but she is scheduled to speak.
I was just asking because Sally's one of the people who had set at least one of these reforms in motion a number of years ago through testimony on Capitol Hill. Is Maeve Carey here also?
Yes. Hi.
Thank you, Maeve. Let me just recognize Maeve. Maeve is with the Congressional Research Service, and I'd just like to thank you, Maeve, for not only participating, but also sharing your expertise with us and Jesse throughout the research process. So very happy to have you here. And I see Tom Sussman here, a senior fellow, and we're very glad to have Tom. in large part because of his expertise on Congress, which is obviously what we're dealing with here. So let me just offer two more thanks, and then I'll turn it back over to you. The first is to thank Kevin for answering our call to step in as the acting chair for this project. Carrie Colonnese is enjoying a well-earned rest as the committee chair. And so thank you so much, Kevin. We're very glad to have you. You're certainly a very worthy replacement to Carrie, I needn't say. And I look forward to your chairing the proceedings. And then finally, and secondly, I'd like to just thank Jesse Cross for giving us such an outstanding report. He really has, we're really fortunate to have his expertise on this project. I hadn't heard of Jesse. I hadn't heard of you until you had published that article with Abby Gluck entitled, I think, "Congressional Bureaucracy in the Penn Law Review," which was outstanding. And when I learned that we were able to have you as a consultant for this project, I was very, very excited, as we all were. So thank you, Jesse. And I very much look forward to hearing an overview of your report when we get to that point. At this point, let me just turn it back over to Kevin with my thanks once more, Kevin.
Thanks so much, Matt. I'll try to stand in for Carrie. There's a big shoes to stand in for, but I'll do my best. So let me just kick our meeting off in a formal way with some reminders important to our proceedings. So please note that only ACUS members, including government members, public members, senior fellows, liaison representatives, and special counsel, whether or not on the committee, and their designated alternates, have full speaking privileges. To avoid background noise, as I've mentioned, I'd ask you to keep your microphone on mute and either use the Zoom hand raise feature or add a comment in the chat if you'd like to speak. I'll then call on you and you can unmute yourself. Please then remute yourself when you're done. I'd ask ACUS members and their designated alternatives to use webcam to facilitate our conversation together. With respect to attendees other than ACUS members and alternatives, participation requires the unanimous consent of committee members. Time permitting, I'll consider calling on such attendees at appropriate points and will presume that committee members consent absent their raising an objection. If any such participant would like to speak, please so indicate to me using the chat feature in Zoom or Zoom's hand raise feature, and wait to speak until I called upon you. You can then unmute yourself and please remute yourself when you're done speaking. For all participants, please use the chat feature only to indicate that you'd like to speak. That is for committee members and alternatives, except for committee members and alternatives to vote when asked. Please do not hold any sidebar conversations or put any substantive conversations in the chat feature. Only members of the Rulemaking Committee, including government members and their designated alternatives, public members, senior fellows, liaison representatives, and special counsels have a right to vote. Please do not vote unless you're a member of the committee. Mark Thompson and I have a list of committee memberships, and we can answer any questions in case you're in doubt about your membership. So with that formal introduction, I wanted to say informally, I'm going to turn it over to Jesse Cross in a minute. I want to thank him in advance for the truly excellent and thorough report, which I know is going to make the committee's considerations of these recommendations a lot more grounded. And so I really appreciate all the effort that's gone into them. So, Jesse is currently Associate Professor of Law at the University of South Carolina, and I'll turn it over to you, Jesse.
Great, thank you. Thank you both, Kevin and Matt, for those very kind words. I appreciate that, and thank you all for having me here today. So for my remarks, I thought that before discussing my report's recommendations, I would give a brief overview first of the Congressional Review Act itself, even though I'm sure folks are all familiar with it. But you know, the CRA is designed to empower Congress to review agency rules as they're being finalized, and to give Congress an opportunity to potentially overturn those rules, and especially to do this in a post-Chadha world where any review is going to require bicameralism and presentment. And the CRA strategy to accomplish this goal really has three components to keep in mind. The first is it includes submission requirements for agencies. So agencies must submit reports to Congress and GAO that include the rule itself, as well as some basic information about the rule. And the main submission here is one I call in the report an 801A report. And the idea is that these submissions put Congress on notice about rules that are coming down the pipeline, alerting Congress to rules they may want to review and even overturn. So that's the first prong. The second prong of the law is it provides for delayed effectiveness of agency rules. It says rules cannot go into effect until these submission requirements I just mentioned are met. And for what the statute calls major rules, it provides that these rules are subject to an additional delay. They cannot go into effect until 60 calendar days after the submission requirements are met, with a few exceptions. And these delayed effectiveness provisions ideally provide Congress with a chance to review major rules in particular before they become binding, though as you see in the report, that doesn't always happen. And then the third prong, one that we'll probably talk a lot about today, is the statute provides expedited procedures for congressional review of rules. And these provisions remove a variety of hurdles and veto gates in the typical legislative process to allow Congress to act swiftly to overturn rules it dislikes. The hurdles it removes are nearly all in the Senate, with one minor exception. And the primary impact of these procedures is they allow CRA rule disapprovals to avoid any threat of a filibuster. And these special procedures are available only for a limited time after Congress receives a rule submission from an agency. So those are kind of the three big interlocking reforms of the CRA: agency submission requirements, delayed effectiveness of rules, and expedited procedures that allow Congress during a limited review window to overturn rules through a streamlined process. Now, there's been general agreement, as I mentioned in the report, that this system has not functioned entirely as intended. And the SACUS project called for an inquiry into three possible technical reforms to fix it. And to conduct this inquiry, I revisited obviously the statutory text and structure, as well as digging into the legislative history of the CRA, in order to understand how these proposed reforms might interact with the sort of foundational goals of the statute itself. And I conducted interviews with key actors both inside and outside Congress. Matt alluded to these. I'm very grateful for the people who participated and really helped coach me up on this. But to understand how these reforms might play out in the real world and in the contemporary Congress. So to say a word about each of these reforms and the recommendations attached to them. So the first is the proposal to switch to electronic submission of 801A reports. And for context, today, agencies submit these 801A reports by hard copy. They are not required to do so by the CRA itself, but instead by the interaction the CRA has with chamber rules that require various submissions to Congress to have what are called wet signatures. And these paper submissions create a lot of bureaucracy, both for Congress and the agencies. They can create significant uncertainty about the exact timing of congressional receipt. And in the report, I walk through the benefits and drawbacks you might get with a switch to electronic reports, but generally recommend that. I think that makes a lot of sense to do. The second reform that the report considers is revising and clarifying the various time periods that are laid out by the Act. And for context, to create a system of rule review, the statute outlines these multiple, often overlapping time windows. And if you want to see what they look like, there's a chart in the report on pages 27 to 28 that gives detail on a number of these windows. And to just flag briefly for you a few of the key windows here on that chart. You know, the first I would flag is the one under section 801A3 of the statute. And this window specifies the period during which an agency must delay the effectiveness of any major rule. That window generally extends for 60 calendar days. There are certain triggering events that can lengthen or shorten it, but generally it's a 60 calendar day window for delayed effectiveness of these major rules. The next one just to highlight is section 802A of the statute. This window specifies the period during which Congress can introduce a CRA resolution to disapprove a rule. So it's this introduction window. And it is also 60 calendar days, but it has an exception for adjournments of greater than 3 days. So long adjournments can stretch this window. It's a window that can lengthen but not shorten. And those instances where it lengthens have become less and less common because it's more and more rare that Congress actually adjourns for greater than 3 days. Congress now uses pro forma sessions to strategically break up those adjournments. So you don't see that getting used as much. A third to flag is section 802E. This is the window that specifies the period during which the Senate has access to the CRA's expedited procedures for disapproving a rule. And those go for 60 Senate session days, not calendar days. So you can see how on the surface, these windows sound identical. They both have the number 60 in them, but it's pegged to session days, not calendar days. And that creates what I'm describing in the report as two-way uncertainty, meaning at least in theory, that means that window could both lengthen and shorten from the 60-day baseline because Senate and House days are these artificial constructs that you can kind of play with. And then kind of to jump up a little bit on the chart, one last window to flag is the one under section 801D, what I call the look back window. And this is the window that provides a period at the end of each session of Congress, where if Congress receives a rule submission from an agency during this period in this window, Congress will not only have its usual introduction and fast track windows to review the rule, but it also will get a second full review window in the following session of Congress. And this is the window I think it's fair to say that has caused the most consternation inside Congress because it is especially difficult to calculate in real time. And this is true for a few reasons. First, it's the one window that's calculated retroactively, by which I mean it's calculated by counting backward from the date of sine die adjournment of Congress. And that date of adjournment itself can move around a bit. And then second, it's counted backward in session or legislative days. It's 60 or session or legislative days, which again, as I mentioned, itself is subject to two-way uncertainty. So you're counting backwards with an uncertain ruler, basically, and from an uncertain endpoint. So these factors mean that it's a real guessing game what the duration of that look back window will be, basically until it's already passed. With respect to these windows, it's worth briefly noting the role the Senate parliamentarian plays, because they pop up a number of times in the report. So insofar as the ramifications of these time windows I just described are for Senate procedure, for getting access to fast track Senate procedures, their interpretation and application is a matter of chamber rules. And on those matters, the Senate typically defers to the Senate parliamentarian. So she has an important role to play in interpreting and giving effect to the CRA in this regard. So the report makes a number of proposals to reform these windows in order to bring increased clarity and simplicity to them, which I'm sure we'll discuss further. These include specifying a fixed start date for the look back period, with the introduction period, either eliminating it or maybe aligning it with the Senate action period. And also just formalizing somehow, some of the interpretations from the parliamentarian that have accrued around this statute and that make it especially hard for outsiders to understand. So that's the second reform the report looks at. And then the third reform is this possibility of adding to the CRA a way for Congress to initiate these various time windows I just described in the absence of an agency submission. So you will notice that for all the time windows I just discussed, they're all structured as sort of a counting of days. And the event that triggers that counting, at least partly, is always the submission by an agency of an 801A report. Well, that begs the question, what happens if an agency just doesn't submit the report? Does that mean the agency can simply avoid triggering these windows and thereby avoid congressional review altogether? Well, surely that can't be the answer. And to avoid it being the answer, Congress has invented this de facto process whereby it can unilaterally jumpstart these time windows if necessary. And under this process, Congress requests a GAO opinion of whether an agency action actually is a rule. GAO then issues an opinion, And if it determines the action to be a rule, Congress then provides for publication of that GAO opinion in the congressional record. And the parliamentarians, as a matter of practice, have treated that date of congressional record publication as the start date for these windows, even though that's not provided explicitly in the statute anywhere. So the report recommends that it would make sense to actually formalize that process into the law. And it explains some kind of ancillary policy recommendations that it would make sense to adopt along with that to make sure this process works in a way that advances the core goals of the CRA. So with that, I'll stop there and I look forward to the discussion.
Thanks so much, Jesse, for that overview. I think that's really helpful. And I also wanted to just thank everyone for their time here today for evaluating and thinking through these recommendations. As anyone who's ever tried to count days under the CRA know, this is a complicated territory. So I'm thankful for the overview. I thought, that it makes sense in this context to, I think, just proceed block by block and line by line. And we have a pretty technical set of revisions here. So my thought would be that we would just start looking at them one by one from the top. We don't yet have a preamble. I think that's going to be a complicated task to draw on. So I thought we just begin there, and I will see if I can manage seeing the raise hand feature, just 1 second, as well as the text that we've got here. Oops. Just see if I can do that. Sorry. Mark, you can help me to see the raise hand feature in addition to the text that you've exposed. You can see the raise hand feature. I'm not sure I can. Sorry about that. I'm pretty Zoom literate, but I'm just 1 second here. Side by side, maybe. Okay. So let me just begin while I'm struggling a little bit with my Zoom. If I can't see the raise hand feature, but if anyone would like to speak, let's just turn to the first of the. There we go. I got it now. I can now see the raise hand feature. So let me turn to the first recommendation, beginning under the heading requiring electronic submission of reports required by 5 USC section 801A1A pertaining to electronic versus hand delivery. And I see Bill Funk has his hand raised.
I have a sort of general question for numbers 1, 2, and 3, as well as the first block. And that is, I also would like to second the accolades for Jesse on the report, which is fantastic. I loved it. But the question is whether electronic submission of reports should be required or allowed. And there is some discussion in the report about benefits of having, certainly a lot of benefits of having the ability to submit electronic reports. And there's a little bit about why it might be a good idea to require one way of doing it that's uniform. But I wasn't quite sure whether that was as convincing as the flexibility of allowing agencies to decide whether or not to provide it electronically. And I wonder if Jesse could respond to that.
Thanks, Jesse.
Yeah, it's a great question, and they are both viable policy options. I would say, and you're right that it would certainly provide agencies with greater flexibility. As you weigh the trade-offs of that, my guess would be that it would detract from some of the benefits on the congressional side if you were to have effectively 2 different streams coming into the office of electronic and paper submissions. I think in terms of reducing administrative burden, if that goal is really the one that's driving this, I'm not, for this reason, for example, the report mentions Congress may eventually even want to decide creating uniformity across all submissions by making them all electronic, just because the more streams you have coming into the clerks and the parliamentarians, probably the more you're adding to instead of taking away that burden. So I think that's the countervailing value I would consider there.
Anyone else want to jump in on this colloquy? Let me turn then. So let's just maybe read aloud recommendation 1 and see if it prompts any further thoughts. Yeah, thanks for a little bit of amplification there on the size. That's great. Congress should amend section 5 USC section 801A1A to provide that reports required by that provision, parentheses 801A reports, be submitted to Congress and the Government Accountability Office, GAO, electronically rather than by hand delivery. All right. I don't see any. Let me give another moment here. We can always loop back if there's other things implicated here, but it looks like I don't see any. If you do raise your hand, because I can't see you otherwise. So let's move on to number 2, recommendation number 2. In the event Congress does not enact the amendment described in paragraph 1, both chambers of Congress should modify their rules or policies to require electronic submittal of 801A reports. Yeah, I recognize Michael Hertz, and then after Michael, Jeff Lubbers.
So this seems utterly sensible to me, and I have nothing very meaningful of substance to say. I have 2 wordsmithing suggestions, both in line 6. I would suggest houses of Congress rather than chambers of Congress. Houses is the word that's used in the CRA itself consistently. And I would get rid of the word still, which is a little odd and unnecessary. And I feel not very strongly about either of those things.
Great, they both seem like good suggestions. Let's see.
Can I jump in for one thing
Jesse,
there?
yeah.
I think the houses point is an excellent one, and I really like the one on still. I think I agree. It reads a little awkwardly, and I see the impulse there. I think just to give context, what is being finessed there is technically certain parts of the CRA are themselves exercises of rulemaking authority. At least that is what Congress has tried to assert, especially in section 802, where that's more of a concern than it is here in 801. But you have these provisions that are playing this complicated role of being enacted in statutory law, but are Congress is at least trying to frame as an exercise of rulemaking power. So I don't think you need still in there, but I think that was the so just so you're aware of what the goal was there, is to not to make sure we avoid any negative implication that we think the statute is somehow not an exercise of rulemaking. So that's just a factor to consider with that. But I still think striking it is fine as well.
Okay. Before I turn to Jeff, let's make sure there's any other comments on these 2 revisions. Okay, then I'll turn Jeff Lubbers.
Thanks. These are written in such a specific, without any exceptions way, and I was just wondering whether there might be, you might put a qualifying word in here, ordinarily, or except where there's good reason to do otherwise, or something like that, because we can't foresee all the possibilities that it might not be possible to send in documents electronically, and there might be a need to to use some other mechanism. So if we're suggesting kind of statutory, it's almost like we're suggesting statutory language here. And I just worry that it might be, we might need some exceptions.
Jeff, do you have some, I guess we could work with some language in mind, you know, in this sort of scenario that electronic submissions are not possible.
Feasible.
Feasible. So Congress electronically, rather, you know, something, think a little about where that would go. Okay, feasible. To the extent that that's to the extent feasible is always a possible. Do others have? Let me see. I see. Kirki Datala. Sorry. Did you want to speak on this? Did you want to speak on this point or another point?
It's on paragraph 2, so it's not on the
feasible. Okay.
Yeah.
Thank you so much. Let me just see if there's others who want to jump in on Jeff's suggestion, and then back to Jeff whether you think this, to the extent feasible, covers that or creates other problems. And Jeff, do you want to jump back in?
I don't know if that language is perfect, but it meets my general concern. Maybe it could be moved to provide that to the extent feasible reports, move it up to the first line perhaps, or I mean, I like the idea of making it the default rule, but I just didn't want it to make it too strong.
Okay, to the extent feasible. I guess the one.
I was going to put it after provide that to the extent feasible.
Yeah.
I see a couple different hands here, and not sure. Bill, Michael, and Amy, do you want to talk? Let me just call on Bill first. Bill, are you interested in talking about what we're now going to call maybe the Lubbers Amendment?
Yeah. Thank you for calling on me. My video is not working properly, so unfortunately you can't see me smiling. But I love this. Is it? So I tuned in a couple of minutes late because I had a bad information from my supervisor about when we started. But is there any? Would there be an objection to just saying to allow required the reports to be submitted electronically? I mean, if we're going to start, so requiring them to be submitted is great. I love it. But now we're backing off of that a little. Well, what if we just said allow to, and then agencies could do it at however they prefer?
Yeah, in a way, our first colloquy was a question about whether this should be allow or require, and maybe
I apologize. Sorry about that.
And I think I could gloss Jesse's remarks there, but in terms of maybe Jesse, why don't you just repeat the gist of that in terms of the work burdens on the relevant offices?
I'm grateful.
Yeah, my response to that was that it is a perfectly acceptable policy alternative to the one proposed here. I think the piece to weigh is that if the goal is to reduce the administrative burdens on the Congress end here, my sense is that generally any approach that creates multiple streams of submissions coming in instead of one stream of submission will be viewed as making the burden worse rather than better. And so on that side of the equation, my guess would be that you would encounter folks saying, well, I thought the point of this was to make life easier for us and you've just made it harder. So that would be the concern. I'm not saying that counsels one way or the other. There are a variety of other benefits I think you get just by having some submissions be electronic. it may be that the culture would just drift toward doing it that way anyway, but that would be what I would say to think about as potentially being on the other side of the scale there.
So let me see, let me turn then, Bill, unless you want to jump back in.
No,
I'll
just
turn-
understood. I just withdrawn. I didn't realize that it happened before, and I
Okay.
apologize for joining late.
No problem. To Michael Hertz.
So I almost always agree with Jeff Lubbers, but I don't like this. It reminds me of the E-Government Act, right? To the extent practicable. And, you know, the E-Government Act was written 20 years ago or whenever. And at this point, it's completely practical. And likewise here, it's completely feasible to do it electronically. I mean, I just don't know the circumstances where it wouldn't be feasible. And, and, you know, we qualify so much in our recommendations. I don't want to qualify when unnecessary, and I don't want to imply that it's not feasible in any way. It's we don't require hand delivery when feasible under the current rules, and we don't have to require electronic delivery when feasible under the new ones. For that reason, allow. I'm more happy with allow, because I think the impulse of everyone will be to do it electronically anyways. That's part of what the report tells us. And that would accomplish the shift. But I don't want to, you know, in general, provisions that invite agencies to ignore technological alternatives because they might not be feasible, I think are a bad idea, because they imply there's a bigger barrier there than exists, and these are good things.
Thanks, Michael. Let me see, I see Amy Bunk and Anna Shavers. Amy, are you also on this point?
No, I was going to raise something else, so I can wait.
Okay, Anna, are you on this point?
No, it's also on another point.
Okay, so let me then, we've got I don't know whether Jeff, do you feel like you want to maintain this to the extent feasible, or do you think it's kind of adding a qualification where not necessary? Let me just turn to Jeff.
Mike makes a good point. I'm really thinking of maybe the language should be changed to say something like except in extraordinary circumstances. I mean, I like it being the primary rule, but I just don't think we can foreclose the possibility that there might be some circumstance, power failure, I don't know. You know, we don't require, under the E-Government Act, we don't require public commenters to submit their comments electronically in rulemaking still, even though most people do. You know, there's a possibility that an agency might feel like they can't do it on a certain day. So I don't feel that strongly about it. It just seemed like we were just being a little too doctrinaire.
I'm sorry, Kevin. I'm just wondering, I mean, filing requirements, electronic filing requirements are pretty common in a lot of places. They're common in the executive branch, common in the judicial system. Is it customary to have some kind of exception in the event there's, I don't know, a nuclear catastrophe or a power outage or whatever? I mean, I just don't, is it customary in this context to write in an exception? Or can you sort of leave it to the bureaucrats in Congress, so to speak, to address some kind of exigent circumstances that might arise?
One thing also to jump in and think about, and I'm afraid this is just going to add more complexity versus giving clarity, but is that, you know, for this particular rule, you're ultimately going to have a decision by Congress about whether a submission has sufficiently accorded with the law to trigger the various procedures under the Act. And so those interpretations, my understanding is, are sometimes done in a more flexible, pragmatic way than one might expect if you're just thinking of typical statutory law. I think there are some submission requirements, for example, for the Secretary of maybe Defense, where the statute says it must be electronic, and I don't know that they've required them to be electronic. And so, unfortunately, I can't give you a definitive answer on that. You'd have to talk to people who are probably You'd have to talk to the parliamentarians about this specific question, but it is an area where I think there has tended to be more flexibility for pragmatic realities as they pop up than people may expect from the face of the statutes. So just to put that on your radar.
So I'd like to see if we can get to some closure here on this point. It could be the kind of the question is whether it's too much of a qualification, as Michael Hertz was suggesting, because most things are feasible to submit electronically. And then as Jesse remarks, is there not filings in court? There's a little bit more flexibility there. And whether that language is necessary or something like, or you could put on the very end of recommendation 1 in line 4, when electronic delivery is feasible, right? Which is I think, yeah, is feasible. That would be another way of accomplishing, which I think maybe narrows a little bit. The extent feasible really is just, it clearly is qualifying, the preceding phrase there. I can't really see anyone to kind of gauge visual reactions. See if I can find a gallery view. I don't know, Jeff or Michael, do you want to? I don't mean to pit controversy against long-term ACUS contributors here by any means, and friends. So
I mean, I've said my piece. I don't think anything to add.
Jeff, do you?
I think I said my piece too. I mean, I almost let Jesse decide.
Kevin, I just want to emphasize something here. We ultimately need to let the committee members decide. And, I'm not a committee member. Jeff's not a committee member. Jesse's not a committee member.
I will just say, prompted by Matt, I'm looking at the Federal Election Commission regulations about electronic filing of reports. And some filers have mandatory electronic filing, and there is no language leaving it out for extraordinary circumstances, feasibility, or nuclear holocaust. So that's one data point.
Well, maybe
Kevin, can I say something here? I interpreted Jesse's comments to suggest that you don't need the exception, because in real life, if it's really necessary to make an exception, they'll make an exception. That's what they've been doing already. So it seems like you don't need it because people act reasonably in extreme circumstances.
Yeah, and I see Bridget Dooling has a comment on this too, and thanks for, and Richard Pierce. So thanks for taking advantage of the chat to help order, and then I'll get back to the queue, which I think I'm keeping. So Bridget.
Yeah, just quickly, for what it's worth, hi everybody, Jesse, amazing report, such a huge contribution. And for what it's worth on this, I'm with Michael Herz. I think it's good for this to be in the realm of a requirement. However, I suspect that even outside of, once we're through committee and certainly at the plenary floor, there would be similar discussion. So I think I would encourage actually taking a vote on this so that the committee, comes to resolution as a whole, because I think it would be helpful. If we keep the requirement language, it would be helpful to be able to say that the committee contemplated it and chose to keep it rather than it being in this somewhat ambiguous posture. So I would encourage a vote on this point.
Thanks, Bridget. Richard Pierce on this point as well.
I just want to say I agree with Michael.
Okay. So why don't we go ahead and call for a vote on this? I'm going to ask Mark Thompson, what's the best way to phrase it to get clean voting here? All in favor?
Wait, can I jump in, by the way? Sorry.
Oh, yeah.
I want to elaborate because I think what I said was described accurately, but I'm just trying to think through all the different angles of it. And just so you're aware, I'm thinking about what is triggered by a submission occurring, right? And the idea is It triggers, as I mentioned, all the procedural windows. And so the construction of it in that sense is a rule interpretation within Congress that is subject, as I mentioned, to especially kind of heightened flexibility sometimes in the interpretation, right? The statute says this is the only thing that can trigger it. Well, the parliamentarians have said GAO reports also trigger it. There's some innovation in that regard. I will flag the other thing that the submission could trigger is determinations of whether the rule is effective under 801. And that gets into a question where it may be subject to your kind of rulemaking internal chamber interpretation. It may or may not be subject to judicial review. That is a thorny topic of itself. So I just wanted to go even deeper in the weeds, but give the caveat that I think it's language that forks off on both of those roads, if that makes sense. So with that, sorry, you can continue on.
Thanks, Jesse. So just in the structure of voting, I might actually ask for a little support from Mark, whether we would do a voice vote or a vote in the chat feature on this.
So how to conduct the vote is largely up to you.
Okay.
I'll frame the question for a vote is also largely up to you.
Okay. Let me just, I think we might be able to do a voice vote, and then if anyone objects to that after we've done it, we can do a vote in the chat feature. So I'm going to ask in a moment all those in favor of the Lubbers amendment, which is adding the language to line 4 and 5 when electronic delivery is feasible, to say aye.
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 Okay. And then I'd like to ask all those opposed to the Lubbers amendment as described to say nay.
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 I think the nays have it. So unless there is objection, I'd say let's not adopt the committee is not adopting the Lubbers amendment. We turn now back to the ordinary queue, and I'll also ask, I think something maybe I should have mentioned earlier, if you have a comment that directly pertains to the question raised, why don't you put that in the chat to me, and that's a way of breaking the queue, and otherwise I'll go by the hand raised queue. So back to Kirti Datla, sorry, apologies.
No worries. So I had a question about paragraph 2, and it relates to the discussion of the original signature requirement and the parliamentarians' role in all this, which I think is on page 26 of the report. I just wasn't sure whether the report was indicating that even if the statute described in paragraph 1 happens, the parliamentarian might still be able to say there's an overriding original signature requirement that would kind of graft a paper trail back onto this. And if that is a real risk that we think is going to happen, whether the like statutory text that we're recommending should specify that it overrides the signature requirement.
Thank you very much. Jesse, can I turn to you to think through that?
Yeah, and the answer I think is complicated or murky, as you may have gleaned from those paragraphs. There was one suggestion by a past parliamentarian that this potentially, at least if you're requiring electronic submission, might have to be a change made in statute. So now that said, my sense is that is not the prevailing view, and that you could do this through changes to chamber rules. And it is difficult to see why you wouldn't be able to, as far as I can tell. If folks have thoughts, then I'd be interested to hear them. But my sense is that if Congress unambiguously said, we are changing chamber rules, we are modifying the wet signature requirement, which itself is just a chamber rule, for these CRA submissions, that should suffice for the parliamentarians. But if you have lingering concerns because there is this one past statement on the record by a parliamentarian suggesting maybe otherwise, then that sort of, the statutory road gives you an extra kind of hammer in that situation.
Can I just ask a quick follow-up question? It sounds like you're saying everyone agrees that the statute, amending the statute takes care of, there's no further need to amend the rules, like to make sure the parliamentarian is on board after that, that what's specified in section 1 is sufficient.
I think that's right, that would be taken as an overriding expression of congressional intent that was meant to trump the wet signature requirement, is how I understand that the parliamentarians would take that, especially for such a foundational area. I think when it's kind of done maybe in a small corner of their world, they might think, well, surely they didn't mean to trump this general rule we have for this one narrow lane. Here you're dealing with like half the submissions they get. And the intent is pretty unambiguous if you come into the statute now and say, take these electronically. So I think it would be taken as being unambiguous on that, yeah.
Okay, thank you. If I can ask, once you've spoken, if you've had your hand up, to lower your hand, and make it a little easier for me to keep the queue. So I think I have Amy Bunk is up, and then Anna Shavers.
Hi, good afternoon. I'm hoping that my suggestion is on the lines of houses versus chambers. In the first recommendation, where it says rather than by hand delivery, I think the hand delivery should change to hard copy, because it's not the statute that requires hand delivery. It's a combination of the statute and the chamber, the House rules. But that's just my suggestion. Thanks.
Thank you. Jesse, do you have any comment on hard delivery versus?
No, I think that's a smart change. I think, especially where you have a lot of submissions by mail. I mean, that's somebody's hand is delivering, but not necessarily an agency courier. So given that, I think the hard copy point makes a lot of sense.
Okay, great. Let me turn to Anna, and then I'm going to take up again a piece of Bridget's comment that I want to come back to.
Yes, my comment is, and a question is more toward wordsmithing also. I think I want to commend Jesse also for the report, and he can probably clarify this for me really quickly. So the heading of this recommendation is requiring electronic submission. When we get down to paragraphs 2 and 3, we talk about submittal. And I read through the report, I couldn't really see any reason to require the language submittal rather than submission. As I understand those two words, they're really interchangeable in terms of the meaning of them. And so I was just wondering, would it be better to use submission, because that's the heading, rather than submittal? Maybe Jesse can tell us whether he thought about that.
I did not. I would be fine with going with either of those. The language in 801 A1A is just shall submit. It uses it in the form of just shall submit. So any version of off of that route, I think is statutorily accurate.
Thanks, Anna. Let me take
Well,
this.
that would be my suggestion, to change it both in paragraphs 2 and 3. I know we haven't talked about 3 yet.
That's, we can go ahead and put that in there. So let me pick up a piece of Bridget's suggestion, which seems like a good one, which was that we should take a vote. We've had some discussion here about whether the recommendation should be requiring submission of reports electronically or merely to permit them. And it seemed like we had some back and forth. Maybe it'd be worth the committee voting, which would give maybe ease the evaluation when we get to the plenary, that on this question of that we are in favor of requiring submission by electronically, as opposed to in hard copy. So maybe I can put the vote this way, which is, does the committee endorse the recommendation 1, which requires submission electronically rather than in hard copy, as opposed to more permissive language? So phrased, let me see, all opposed to that approach. All in favor of that approach.
Aye.
Aye. Aye.
Okay, thanks. I think that might be helpful going forward. So let's, unless there are other questions on the first 2 recommendations, let's turn our attention to the third, which I'll endeavor to read aloud here. In the event that Congress, in some manner, mandates electronic submission of 801A reports, it should establish procedures governing how agencies may electronically submit 801A reports. All right, sounds like good silence there. So we hope that they will, we hope that they'll endeavor to establish such procedures. Okay, good. Let me then move on to what I think is going to be more complicated turf, certainly is more complicated turf in the recommendations. So the second set of recommendations are under the heading simplifying and clarifying the procedures for determining relevant dates under 5 USC sections 801 and 802. Okay, and so recommendation 4, I don't know that is there, I'm not sure much is added by my read aloud here, so maybe I'll skip that and just ask anyone if they have any comments on recommendation number 4. Michael?
Sorry to talk so much. I did wait for other hands to go up. So I had a couple questions, and a lot of this has to do with sort of how ambitious we want to be here. The most narrow is I don't think this is just about procedures. So I think that the title of the section, right? It's also just about, you know, how it's not about procedures for determining, I think. But anyways, more substantively, so look, one of the things always about looking at a set of proposals is you focus on what's been proposed and you don't think about what else might be proposed. And so I have a general question for Jesse, which would be what he didn't put in here. Okay, what was left out of these? I'd be curious. Secondly, one specific thing that comes to mind is, you know, it's not clear to me why one needs a look back period with regard to the period between one session of Congress and the next, especially how the thing has come to operate in practice. So one bolder thing would be to like rewrite the statute, and it applies to look backs between Congresses, but not between sessions. I'd be curious what anybody thinks about that idea. And then the third thing is the fixed date makes tons of sense to me. It feels like a little bit of a missed opportunity to say we should fix a date that kind of corresponds to how the old system where the old system landed us. I mean, one ought to at least think, is there a right date? Right? Is there a time period that's appropriate, which may or may not be where it happened to land us because of the number of legislative days? I don't know that there is, but I'd love to hear, you know, thoughts from anyone about whether they think there is. And in that regard, look, in practice, this is really about midnight rules, and ACUS has a midnight rules recommendation. And the place where all this is serious is where there's been a change of the party in the White House, and the new president is the same party as both houses of Congress after an election, which is where the midnight rule issue is most salient. And there's a concern about rushing, and there's a concern about legitimacy of rules after an election, and so on. In the midnight rules recommendation, my recollection is that ACUS said, okay, it's 90 days before inauguration. I think that's right. One could also just say it's after the election, right? Beginning Wednesday after the election, something like that, but tie it to the election as the period where we're kind of worried about what it is the administration is up to. Because it's more about that than giving Congress, as Jesse points out in the report, than giving Congress time to do this. So those are sort of the general big picture concerns that I have.
Thanks, Michael. Jesse, do you want to wade in first on that? And then I've got some other hands here.
Yeah, I think to the question of kind of how I approach the scope of the recommendations here and sort of situating them in the broader universe of policy options, the set of the initial ACUS call on this project was for technical amendments, technical recommendations, and so I approached this with kind of the hat I used to wear when I was a nonpartisan staffer in Congress when we would write legislation and people would give us authority to make technical tweaks, which I took to mean you should sort of take as given the policy objectives of in this case, the sort of initial crafters of the statute, and just think about, work within the universe of what it seems were their goals and try to think about how you might tweak the system and be faithful to that. And so the recommendations I give sort of stay within the universe of the goals I could find people articulating for what they were hoping these interacting systems would do. And, and so a value like the one you flag about, to the extent the statute has shifted toward sort of fulfilling a different value, which is just policing what an administration is up to. That was not one that I put into the calculation, but that's sort of how I framed the analysis in this part, and is how I sort of set the universe of what seemed to me to be recommendations within the scope of this report, versus ones that are for you all to consider, but that go beyond kind of just trying to fix the wheel that already was there, essentially.
Thanks, Jesse. I see Bridget has her hand up.
Yeah, thanks. This is for folks on the phone. It's Bridget Dooling. I'm a senior fellow with ACUS. And I think something for the committee's consideration is a choice in this provision and others. So sort of a general choice the committee should make about whether it's trying to come up with revised procedures that basically land us in the way that the CRA already functions. So like with this particular one, are we trying to preserve the amount of time that Congress has had to do its look backs, and just coming up with a slightly more rational way of expressing that, and so in this case, this look back recommendation is anchored into, at the end of this clause, it says, as a matter of recent history, that this is about how long it's typically lasted. I think Michael puts on the table an alternative, which is to actually think about how long that period ought to be, separate from how long it has been in the past. I don't have particularly strong views on that, but I do think that's an embedded choice within how the committee proceeds on all of these date provisions. Whether you're really just trying to simplify and maintain the status quo while making it a little easier to figure out what that status quo is, or you're trying to actually shrink or expand the time periods that Congress has to do its work here.
I wonder whether it'd be useful to turn to Matt Weiner or Reeve Bull a little bit on how the project was set up and the sort of kind of early grounds for it in terms of the scope question.
Reeve, let me turn to you, but before doing so, let me just sort of give my opinion here. I don't think we should sort of be parsing the legislative history of this recommendation project, so to speak, and asking what was intended. I think we should confine ourselves to the project description that the council approved and that appears on the website. And the second item on that project description refers to making it easier to ascertain key dates and time periods relevant to review of agency rules under the CRA. I think ultimately it's just really up to the committee to decide whether the kind of amendment that we're talking about here, the kind that Michael is proposing, or something related to it, falls within the scope of the project. I mean, I think that's kind of the bottom line here with respect to the scope of the project, but sort of inquiring into like what the ACA staff might have thought when originally scoping this project, I think is kind of irrelevant at this point. That's my own perspective on the subject. Reeve, and I'm not going to assume the role of a, to use a kind of a metaphor here, I'm not going to assume the role of the parliamentarian and decide what the scope means. I think that's for the committee to decide ultimately. Reeve, what do you think?
Yeah, I agree with that completely. I would really defer, to the committee on that point, like Matt, and if they feel that that's fairly within the scope, as it's laid out on the project webpage, then I think the committee should feel free to, proceed in that direction.
And I guess I could add one more thing. If the committee were to go in the direction that Michael is proposing, I certainly wouldn't be of the position that the recommendation should be withheld from the assembly at the plenary session. I can't speak for other council members on that front, but I can speak for myself in that regard.
Bridget, I see your hand slot. That may be an old hand from before.
No, I just wanted to clarify, Matt, when you said we shouldn't be consulting the legislative history, you were using that in terms of internal ACUS deliberations, not actual looking at congressional legislative history with respect to CRA, right?
Yeah, I guess it was kind of a small attempt at humor here to try to draw upon a kind of an analogous concept. But yes, that's all I was referring to.
Yeah,
like
well, I found it hilarious.
I mean, Mark, just to disclose our internal processes, I mean, Mark was the one who originally drafted this proposal. No offense, Mark, but I don't know that it matters what you thought. So it matters what the council approved at the end of the day, and what the council approved is what I just read a moment ago.
Could you just, thanks, I think that's really helpful. Now, can you just read that language, since you have it at the ready there, just one more time about this?
Sure, and I'm reading, and by the way, this is all public. This is on our website. The project description says that the project will consider three things, and one of them, the second thing, is where we are now, which is making it easier to ascertain key dates and time periods relevant to review of agency rules under the CRA.
I see Jeff Lovers and then Michael Hertz.
I'm going to agree with Michael. But he's raised two separate points here. One is whether it makes sense to have the look back in between sessions. And I guess I'd have a question for Jesse. Has Congress ever invoked the look back after a session rather than after a Congress? If not, then maybe it makes sense to recommend that be changed. But with respect to the second suggestion that Michael makes, which is to choose a date that's more related to what the act has become, which is a way to police midnight rules from a previous administration, I think that's a separate question. I think he makes a very good point about it. But I don't think the act was originally thought to be that. I mean, it's turned into that. And if we were to make a recommendation that said that the look back period should start the day after the election or something like that, we'd be acknowledging what the act has become.
Thanks, Jeff. Michael Hertz.
So this has been very helpful. I think that probably the question of sessions as opposed to Congresses is outside the scope. As that's a more kind of substantive change to how the act works that, but if Jeff wants to pursue it, I won't stand in the way. On the second point, to me, if we're recommending a date certain, it just is foolish not to think about what that date certain should be. Now, it could be we can't agree on that, or it's just too hard to say, and so we fall back on the average of past dates or something. But as long as we are shifting to a date certain, I would read that as within the scope of the council's approval, precisely because it seems so perverse to not think about it if we're making that decision.
Thanks, Michael. Bill Funk?
On Michael's last point, which is setting a date certain, and my question is there any basis for setting a date certain other than the one that's in the proposal before us in Jesse's report? That is, I thought that we were supposed to, in a sense, have to rely on the report in making our determinations, and coming up with a different date certain. I'm just not sure that I saw anything in the report that would support a different date certain than what has been proposed.
Thanks, Bill. Jesse, do you want to? Right now we're talking about. Maybe I'll let you respond, Jesse.
Sure. I mean, I believe in the paragraph where I mentioned this as an idea. I intentionally floated it as one way that you might pin down the state, because it is obviously one that there's no obvious logical answer to that. This is clearly the right way, and all other ways are wrong. So I think I viewed that as that the window that it provides is more trying to give at least an initial anchor you could work with for that date. I think it would be in keeping with the report to pick any method of calculating this that brought increased kind of clarity or certainty. And so in that sea of options, I saw this as sort of saying, if you want to do that, here's one way to do it that would be in keeping with what Congress has in practice had available to it over the last decade. But I think any method that brings some clarity there is probably within the scope of what the report is offering to you all.
Anyone else? So back to Bill Funk.
I'm going to ask Michael, do you have any other date certain system that you would propose? Because at least one could say, in as much as we're only saying Congress should consider a date, we could say consider a date that it's a matter of history or another one, and specify it.
Yeah, so look, as I said, it's not clear to me what the date should be, or even what exactly the criteria for selecting the date should be. There are a lot of smart people in the room, and I thought someone that there might this crowd might be wise on this. I do think, as I said, we have the Midnight Rules recommendation, and there was that 90-day period in the Midnight Rules recommendation that sort of implicit in that was this sense that it's that period, 90 days before inauguration, where whatever the mechanisms we have, which were not in that one the CRA, but we're delaying the effective date and an extra round of notice and comment and a whole set of mechanisms that were responsive to the difficulty, the legitimacy questions raised by late rules in an administration that in some sense has been disapproved. That's the underlying issue. And if that's the underlying issue, then, it's sometime around the election. that would be the magic date. And ACUS has already latched onto the 90-day one. So presumptively, I'd say, October 22nd or whatever, or October, on that theory. But this is not based on extensive study, thought, or commitment. But you want a date, there's a date.
Bridget Dooling?
Yeah, thanks. I mean, I think part of what's hard about this is that we're thinking about the role of Congress here, but they're not in this conversation. We don't have legislators to help us think this through. And so I guess one thing to consider is whether, and it's possible this outreach has already happened, but I am curious to know what legislators or committee staff think about this and what they might want. I could see incentives for why they would want a longer period or a shorter period, or one tied to the election or not tied to the election. So, I mean, I think it would help, or at least it would be additional information for the committee to have, to know what folks in leadership positions wanted, recognizing those folks are like a little busy right now and might not have time for this, but it would be helpful to know how they view this tool and what their interests are in when it comes to dates and time periods like this.
Yeah, I can see that. Jesse, I don't know to what extent you have foundation in some of your conversations that were the base of the report to help shed some light on what Bridget's asking.
Not in the sense that this recommendation came directly from any high-level partisan staffers inside Congress. There were conversations with folks in various positions in Congress and who put this option on my radar. I didn't come up with it myself. And it draws sort of, I would say more generally on my experience as a nonpartisan staffer, of when people come to you with a fraught question and would say, when we would draft legislation, they'd say, what should this time period be? And you're trying to find a way to offer an option that doesn't just sound like you're taking partisan sides. One way to answer that question in a way that often can get traction in Congress, to say, well, here's what the answer has been the last 10 times this question came up. And that you tend to have receptiveness there. My guess to your, this starts to get into some of the partisan balances of the law, frankly, where the question is, what answer would you get from a committee or a member of staff? I think it probably depends who you ask. And so the question is how to give an option that might be able to get traction within the institution across those lines. Because my intuition is you'd get different answers from different people. But that this was not people, in leadership or committees saying, we think that's the right answer.
Thanks, Jesse. That's helpful. Back to Michael Hertz.
Okay, so let me make a concrete proposal, because this has been very helpful. And in light of what people have said and haven't said, and Bridget's excellent point, what I would propose is that we delete the second sentence of paragraph 4. And language along those lines should absolutely go into the preamble. And this possibility be raised in the preamble, but that the actual recommendation be silent. I mean, it's pretty kind of mushy and non-committal already. Let Congress pick the date, right? Congress, can figure this out for itself. We're not coming down firmly in favor of any particular date. We can mention the recent history in the preamble. But it may be we don't have enough of value to recommend about what that date is to actually include it in the recommendation. So for those reasons, I would just leave the first sentence of paragraph 4, and I would propose deleting the second sentence on the understanding that such discussion would be included in the preamble.
Great. Thanks, Michael. And just as a technical matter, Mark, if you can put a period after look back period, and we'll treat at the end of the first sentence in the quotes there. There you go. So let's discuss now what's the Hertz amendment to strike.
The deletion begins in line 13. Get rid of in fixing, and from there to the end.
That's right. What's the Hertz amendment here would be a strike this second sentence beginning in fixing all the way through the end of this point of recommendation. So I see, so thanks, Michael. Andrew Emery.
Yeah, well, I had a sort of a different, I guess, take on, I guess it was Jesse's explanation of how Congress comes up with dates. As far as what I heard from that was that the dates that we're dealing with that are sort of the train wreck that we're trying to fix with all these different random dates, that was Congress's effort. And so by not sort of suggesting something, we're throwing it back to that possibly. So what would be the harm if we thought there's some reasonable date? Because the idea here, I think, is that we just have a date in here, that having a fixed date is going to give some stability to the process. So why not just pick a date, like say 6 months? So we'll say July 20th. If there's some reason to have a date, now Congress doesn't want it, they can pick up their own date, and then we're back to what we have here. But if having a set date and having Congress say, well, ACUS suggested this, and then they say, okay, sure. If that helps get a set date versus some other bizarre, vague language that we're trying to fix. I mean, that's my suggestion or offer.
Thanks, Andrew. Part of, I guess, what's lost, just one comment of my own, that what's lost if we take the full deletion is we sort of lose this look back period kind of idea a little bit. Others want to jump in on the Hertz suggestion? Bill? Funk?
I mean, I don't feel strongly about taking it out or leaving it in, but what I would like is that Michael's original suggestion of October 22nd, as it were, or 3 months before the inauguration, is a good idea that should either be as an alternative recommendation to the one that's we've just deleted, or in the preamble added as to this one as a possible thing, because it is a good suggestion, and I think that that I don't think we should just put in a date as a recommendation, because we have no basis for making that particular date. What we do have a basis for is saying it ought to be some specific date. So that's why perhaps taking this out and leaving it blank here, but putting stuff in the preamble is a good idea.
Thanks, Bill. Ms. Ness?
Yes, hi everyone. So bear with me a little bit because I went to law school, so I wouldn't have to do math. I'm trying to do math in my head. It occurs to me that if the look back date is too far in the past, the rules could already be effective with the 60-day period that is built in. And that could potentially, that's sort of operationally problematic for, I think, a lot of agencies. And so you could create, I think what I'm trying to say is we should ask for something, if we can, that would work really well for us, and maybe something too far in the past is not that useful in a practical sense. And I hope that I'm making some sense, because I'm trying to think through all of this sort of on the fly here. Because CRA math is hard. Counting the dates is hard, and I do think that there's a benefit to having a specific date, but I hope that I'm making some sense here.
Let me turn to, thanks for that. Let me turn back to Jesse and see what you think would be lost in light of these comments.
Well, first to that last one, I would say that's right. That just as a matter of how this window operates, rules that are issued in the look back period, they are subject to a new opening of the introduction window in the next chamber of Congress, or the next session of Congress. So you can introduce disapproval resolutions subject to an expedited procedure window, but it doesn't change the effectiveness window. So that means you potentially can have rules going into effect, but then being subject later on to potential review. So, and just the bigger this look back window is, the more rules you have that can potentially fall into that. In terms of more broadly, you're wondering, yeah, I don't think, I think I already mentioned in terms of the broader thoughts on this, what I would say, which is that the thrust of the report is that some transition to a more predictable date calculation, and the fixed date is sort of the clearest one you can give, right? Would just, I think, remove a lot of headaches attached to the statute, and that the version I pitched is just one way to give some sort of historical anchor to one option for that. But whether you're silent about that or take one stance or another on it, I think are all in harmony with that goal. So that I think any of those make sense.
Maeve, Carrie from CRS, I believe, has a comment. She's not a member of ACUS, but unless there's objection, I'd like to recognize her. She's recognized.
Thank you, Kevin. Hi, everybody. I'm going to just throw out what I think is a congressional perspective here, which is that by moving the look back date to sometime around or right before election date or election day, particularly given that the CRA is most effective on those, those late issued rules in the final year of an administration, that would have a significant effect on the rules that are eligible for being overturned. I think this is kind of obvious, but is maybe worth just emphasizing. That could be, a pretty big substantive effect of moving the date forward. The idea behind the look back date as it is now is that it's based on the schedules of the chambers. And so the idea is that if either chamber doesn't have its full period of consideration under the CRA, then Congress can, the periods begin anew so that an administration doesn't essentially cheat Congress out of its full period for consideration under the CRA. In other words, so they don't come in at the very end and just dump all the rules, and Congress has a really limited time for consideration. So that's something that I can imagine folks on the Hill being interested in, is that idea that it could really, really narrow the scope of what the CRA is available for. Thanks.
Thanks so much. And I'm reminded that Maeve was interviewed for Jesse's report, so had speaking privileges regardless. Sorry, apologies, Maeve. I think we probably, one thought would be, we're coming up on a half an hour break here. I think it might be worth taking a 5-minute break. So, and then kind of rejoining this conversation about exactly where we want to go. So let's go ahead and take a 5-minute break, and then we'll, at the end, when we come back from break, I'll take Dave Pritzker and others comment, but I'll see you all in 5 minutes.
Kevin, I'm sorry to interrupt. I need to leave the meeting now.
Okay.
But I have a quick comment that I'd like to
let's do that then.
Get in for your consideration.
We can.
And that is, as I read the first sentence of this paragraph, it's.
You're breaking up a little bit.
Can you hear me now?
That's better.
Can you hear? As I read the first sentence of this paragraph, it's ambiguous as to whether it advises Congress to pick one date that applies every year, or whether each year it's to pick a date. My suggestion is, if you mean the former, delete the words each year.
Thank you so much. I think that Jesse, just briefly, I think you mean this recommendation to have a single date that would be for every year. Is that correct?
Right. Well, the idea is that the statute currently provides these look back windows at the end of each session of Congress, and that because those occur annually, you're effectively doing it every year, even though the ones that end up being of consequence under the statute are the ones that are attached to the presidential election years. Right.
So are you?
My point is that as written, it's unclear as to whether it's a single date or whether each year it's a Congress is to choose a date.
Jesse, what's your reaction in the first instance to deleting each year?
Sorry, I'm reading it without it. I mean, I guess the question would be is if you delete it, does it read as though you're saying there's one date we pick, we hereby declare every rule that's after January 1, 2022 for all time will be subject to review. But I had a little trouble hearing just because the sound breaking up what David's concern was with it. So I may be undervaluing kind of what he was said. I apologize there.
Yeah, we want to make sure.
I need to leave. My point is simply that I think it is ambiguous as written as to which way you mean it to be interpreted. And I suggest rewording the sentence to clarify that.
Okay, David, thank you so much for the suggestion. And we're gonna keep wordsmithing that to clarify it. And so let's go ahead and take a 5-minute break, coming back at 37 after the hour. Welcome back. Let's give it another minute or so, or a couple of moments. So let's go ahead and continue to discuss David Pritzker's suggestion for clarification here. I think that we want to make sure that we have a date here that makes it clear this is an annual and recurring. So another possibility would be something along the lines of annually a date. I don't know, a fixed an annual date. That would a fixed annual date. Let's see, maybe we can begin discussion there, maybe with the spirit. So the language we're discussing now is Congress should amend 5 USC section 801 D1 to establish a fixed annual date after which rules submitted to Congress under the Congressional Review Act will be subject to CRA's review process during the following session of Congress. Let's just begin there. Bill.
I was thinking that you could just use fixed date. The recommendation is to amend the statute. They're not going to amend it every year. So they'll do it once and that'll be the date. So just for simplicity, I think that's the easiest way to go, but certainly open to other options.
Okay, that's helpful. Thank you. Dave Rosker?
Yes, I'm not sure I agree with David Pritzker on the ambiguity, but I wonder if perhaps using the word set rather than establish, since we are talking about amending the statute. So Congress should amend 5 USC 801 to set a fixed date each year.
To set a fixed date each year. Yeah, that I think cleans up what it's doing. And then that would, maybe we don't need the annually to set a fixed date. I don't know, Jesse, what would you think about this? Let me let Mark catch up with us here, which would be to set a fixed date.
Yeah, so if the concern was, I think either set or established, I think either way, you're probably good there. I wonder if you said something like Congress should amend the section to set or establish a fixed date after which, comma, each year, comma, rules submitted to Congress, and then you go on. Would that clarify the concern? And now it's clear that what you're doing is not fixing it each year, you're fixing a single date after which, with respect to each calendar year, rules submitted, yada, yada.
Thanks, Jesse. I see, I think Jeff Lubbers is up next, and maybe, unless David, is that an old hand there for you? Yeah, Jeff Lubbers.
I think Jesse just fixed it. You might put in fixed standard date, but I like what he did.
Yeah, it seems like it covers that pretty well. Thanks, Jesse. Should we move on then? So that's maybe, I don't know whether we need to vote, but this would be any objection to the language which we now have, which was to set a fixed date after which, comma, each year, comma, and so on. And any objection to that language? Okay, great. So that's the, I'm not sure whose amendment it is, amendment of the committee there. So now let's go back to the larger question that Michael Hertz raised about whether we should strike and what would be lost from the recommendation, or what it would be by striking the second sentence. I'll maybe make one comment and then see if there's others want to jump in. The language which says at the very end of this language should be sitting, which is, it says, as a matter of recent history, the look-back period under the current has typically commenced. That language, I think, is both really helpful for people to know and seems a little bit out of place in a recommendation, right? It's the kind of thing that seems like it's background information, which is good to kind of, that you hope the reader has it in mind, but it feels a little bit more kind of preambular in style. So I just want, that's a sort of independent comment about this, maybe avoiding the larger question it invokes. So I don't know, do others want to jump in here on this? Jeff Lubbers?
I'm fine with putting this in the preamble. I hope we can cite the midnight rules recommendation of ACUS at the appropriate place in the preamble.
So that this would be, in a way, I think what's in my experience with ACUS, sometimes there's a lot of standard ACUS moves, but this would be a kind of proposal to put something that's in a recommendation in the preamble. That's at least one standard ACUS move. Any further discussion about this before we I ask for, I think maybe a committee vote on it? Michael, do you just want to, before we vote, do you want to, since we took a break and we got interrupted by the Pritzker suggestions, do you just want to summarize again briefly, the grounds for this amendment?
Sure. I think that I think that it's so soft as to not be very helpful to Congress. B, it's a kind of missed opportunity and might steer them inappropriately, or foreclose consideration of when the right date is. C, as you said a moment ago, this does feel preambular. And D, while in a certain way, what I would really like to do is pick a date, right? Recommend a date. I don't think that we are in a position to do that. And so since we are not in a position to do that, to simply say, here's one possible date, doesn't add anything and maybe has a little negative effect.
Thanks, Michael. Jeff, I see your hands up. Is that from before or is that a new hand? No. Any further discussion? Okay, so let's take a voice vote and we can call that back if we need to. So all in favor of the Hertz amendment, please unmute and say aye.
Aye.
Okay.
Aye.
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 Okay. All those opposed to the Hertz amendment say nay.
Nay.
Okay, it looks like the ayes have it. So the committee will then adopt the Hertz amendment. And I think with a recommendation to ACUS Council that this language should appear, or something close to it should appear in the preamble. Okay, great. Thanks for the substantive discussion there. Let's move on to recommendation 5. Let me just give everyone a chance to read it anew. Any discussion on recommendation number 5? Bill Funk?
I just confess that I'm a little confused by it. If Congress eliminated the period during which joint resolutions may be introduced, why wouldn't that eliminate the ability to introduce joint resolutions?
Jesse, you want to?
Well, the way that section 802A is worded right now is it's worded to define, it's got this concept of sort of a CRA joint resolution. And anything that qualifies as that gets the benefits of the fast track procedures, right? And right now, the definition of that joint resolution that gets those benefits is one that first off is introduced in this fixed window, and second has the correct language in it, specifies what it has to say. And so the idea is if you took the elimination approach as opposed to modification, and you just strike the requirement that it be introduced in this window, now there's only one requirement in order to get the benefits, which is to have the magic words in it. And so by striking that, you don't wipe out the ability to have such joint resolutions. You just pull out one of the building blocks you need to count as having that.
Let me then follow up by saying, then to me, it would be clearer to say to either eliminate the requirement that the joint resolution be introduced during a particular period or during a period.
I see Jesse nodding to that suggestion that Bill's just made. Others, why don't we look at that a little bit and see if others have comments on that, which is the language would be eliminating the requirement that the joint resolution be introduced during the period.
Just technically wordsmithing, it should be joint resolutions. There were joint resolutions, period, or plural. Right.
Yeah. Jeff Lubbers.
I just wanted to ask Jesse to talk a little bit more about what he wrote on page 38, where he says that if there's any concern regarding doing this, it perhaps would be about the risk created by removal of the back-end limitation on the introduction of joint resolutions. And it might allow such joint resolutions to be introduced at any time, including years after a rule has been issued. Why isn't that a worry?
Yeah, so so in the report I walked through, by eliminating this introduction window, you create two additional periods in which you could introduce. One is one before the window starts, and one is after the window currently ends, right? And so that the piece you're speaking to is, okay, I was trying to think through what happens if you allow introduction to happen outside this, what we currently have as a fixed window, right? And the idea there is that you can introduce it, but the real procedural payoff of the statute is the Senate, what I call the Senate action window. That's this separate window under the statute when you get to, be filibuster proof and all of that, right? And so most of the procedural benefits of having this joint resolution, as opposed to just any old legislative vehicle to overturn a rule, have a fixed date attached to them already. There's really, and so being able to introduce, 2 years later, but you don't get any of the procedural benefits, well, now it's an awful lot like any other power you have in Congress to overturn rules. The one exception to that, the one procedural bump you still get, even outside of the Senate action window, is this reconciliation tool across the chambers. Is that currently one of the procedural benefits of once chamber one passes a joint resolution, what then happens in joint resolution two, or excuse me, in chamber two, and says that, for example, that doesn't go to committee, it's directly available to the floor. That one procedural piece would already is available ad infinitum once you introduce in the current window. It just means that if you introduced late, you would still get that benefit going forward, but you would have forfeited all the other procedural benefits. So the question is, how much do you care about maybe extending the availability of that one piece? And if you are troubled by it, then option B here becomes more appealing, because that gives a back end to the introduction that lines up with all the other procedural benefits of the statute. If you say, you know what, that really just doesn't matter very much, then you can go with eliminating the window. So that's the trade-off. I don't know if I explained that clearly. I'm happy to talk more if useful.
I think I understand, and I would prefer B, but what if the filibuster were abolished? Would that change the calculus?
Well, you have a lot of procedural benefits in the Senate action window currently beyond just being filibuster proof. So you would still, presumably this CRA process would I would think still have procedural benefits. It's especially currently the 10 hours, I believe, on debate limit, which is one of just a list of procedural benefits you get. That is the one that you no longer need a cloture motion. And so you get out of the filibuster there. But I would think that a number of those procedural benefits would still be relevant. But the more our legislative process just looks like a streamlined one in an expedited statute period, yeah, the more these the difference changes. But I think probably for this, it makes sense to focus on the other half of the scale, which is that particular reconciliation mechanism. That's the one piece that is becoming available on a slightly kind of wider basis. How consequential you feel that piece alone is, because that's where the change will happen.
Thank you.
Thanks, Jesse and Jeff, for that. Others, there's a dense one to get your head around. Others want to jump in on this? Michael Hertz.
Pure wordsmithing in line 20, I'd say eliminate the requirement that joint resolutions be introduced during a particular period. And then that flows into B, which says, if you're going to have a particular period, blah, blah, blah.
Okay, does that, I guess we don't have any problems. I was just looking over the text a little bit above that. It says, which establishes the period, and then you can have eliminate during a particular period. Okay, that seems fine. Any other discussion about that? Yeah, Kirti Datla. I'm not able to hear you right now.
Is that better?
That's better.
Great. So I'm just wondering if the recommendation was to align the dates so that the period ends with the period during which the Senate may, and then the rest of the sentence is there. Does that accomplish the goal of opening up the front end of the window so that early resolutions can be introduced, but not add the new sort of consequence of extension that you were just discussing?
Let's see. So that you're right that would have that effect of addressing that issue of sort of a closed window for that reconciliation process. You don't need the commences for that. What this recommendation would do on that back end, it would probably in practice push the introduction window just a hair wider here. That usually tends to end before the action window does. You get the simplicity benefit of there's just one date for the whole process of everything. Can I introduce? Can I expedite? Can I do anything? Well, there's one date I need to know. On the front end about the commencing, what you would, by striking that, I think you would be implying that you keep the date as it is in the statute. So you wouldn't open up the front end. And what that is right now, the reason we sort of said commences there is that in practice right now, my understanding is these two windows do align, the introduction window and the Senate action window, with when they commence. You would not know that from reading the law, because the statute says they are triggered by that. One is triggered just by receiving this 801A report. The other is triggered just by both report and publication of the rule in the Federal Register. The parliamentarian has given a creative interpretation that says you need publication in the Federal Register for both. So by having commences in there, what you do is basically you're recommending Congress to actually make the statute reflect what they're doing in practice right now. That's what you get from keeping commences in there.
Thanks, Jesse, and for the question. Any further conversation on aspects of paragraph 5? Okay, let's move to paragraph 6. Sorry, Bill Funk.
Yeah, I'm sorry, but this discussion has led me to ask Jesse. It seems that most of the problem here is the disconnect between the Senate action period and everything else. And why not change the law as to the Senate action period? Why not deal with that rather than deal here?
So I think the thought was that in terms of trying to propose reforms that felt like they stayed in the space of again, of sort of technical reforms that didn't wrench the system too dramatically. Of these windows, the Senate action period is the one that's doing a lot more work. That's the one that I think has big consequences. Because how long you have open to you really can drive what you can get through or can't. Whereas as long as you drop a bill in the hopper by some date, you've introduced. And so the idea was that first off, of the two, that one was just the one that if you're staying in the realm of sort of leaving the law functioning largely as is, but just simplifying its operation, you're just stepping on a lot less by fixing that. And then because of sort of the creative interpretations I've mentioned, that's one where the operation of the window and the language of the statute feel particularly kind of out of step with each other. Both because of, as I mentioned, the creative parliamentarian interpretation there, and also because it's got built into it this exception for lengthy adjournments that don't really happen the way the statute envisioned anymore. There's the thought that made it particularly ripe for change. Now, you're right that the action window, that is pegged to legislative days, whereas in practice, the introduction window has drifted toward calendar date operation, which aligns it with the effectiveness window. And in those regards, it is a bit more the outlier. I think you're just probably, you're taking on a more central piece of the statute there. And so that's the trade-off. That's how I think about it.
I just have to say that I'm not sure what is benefited by using legislative days versus calendar days, and certainly in terms of making it clearer to the public and the world at large, almost everybody other than some experts in Congress, as to what a legislative day is. I just think if we get rid of legislative days, I don't know if that's central to the notion of anything in the Congressional Review Act to tie it to legislative days. And that's what creates all the problem here of indeterminacy. And so if we could just eliminate legislative days altogether and use calendar days, it certainly would make things clearer, easier to understand. That I don't see why that would run afoul of any of the, I still call that technical in the sense of we're just trying to create clarity rather than stepping on anybody's toes or changing any policy.
I'll mention for context, and this is not at all to push back. I think all of that makes perfect sense. That you do just in this universe of fast-tracked kind of expedited statutes, you do see legislative days used with a certain amount of frequency. I just mentioned that to say that in that world, it is not a wild outlier. Though I agree that it's really two of the windows here, the action window and the look back window, use this method of calculation, and the others do not.
I don't know, Bill, whether that's something we want to keep. I think you raise this is complicated turf, and there's I don't Jesse's given an account of how it works on the Congress side. And I don't know if there's unintended consequences, but something to keep thinking about as we have a little more time with this recommendation, whether there's something that could go further on clarifying legislative versus calendar days in a couple of different contexts. I certainly, that's not the kind of thing anyone could draft on the fly, but I think it's something to think about if we have a second meeting. So thanks for that set of comments. Jeff Lubbers?
Yes, I'm still troubled by eliminating the requirement. I mean, I think after Jesse's explanation, I could still see that resolutions might be adopted or introduced, years after the rule has already been in effect. And then the proponents of that resolution could take quick advantage of the conciliation process that he described, sending it over to the other house where it's put at the desk and then can be voted on right away. And I just sort of see potential for mischief there. I like the alignment part, but I really don't like the elimination part. But I don't have a vote on the committee. That's the way I feel about it.
Thanks, Jeff. Bridget Dooling.
Yeah, thanks for the opportunity. This all is sort of outside of my realm of expertise, and so I wonder if one of the things we might consider in the time between this meeting and the next one is maybe getting this draft recommendation in front of some other Congress scholars and folks who are just a little bit more familiar with parliamentary procedure than at least I am in terms of thinking through unintended consequences and the shenanigans, that we've sort of been brainstorming a little bit here. I'm thinking of Sarah Binder and Molly Reynolds and people who, are just really steeped in process, just to get some more opinions on, what this might look like in practice, and to give us some input into the committee to help us think about the pros and cons and potential unintended consequences here.
Thanks. I think that would be useful. We've got sort of two different thoughts. I guess one would be, I don't know, and I'll defer to my ACUS colleagues as to the process for reaching out and further vetting. And let me just ask also maybe Jesse to speak to that point, and then actually also Jesse speak to the point of whether the report kind of contemplated the sort of shenanigans that Jeff was mentioning with part A.
Yeah, I mean, in terms of the shenanigans, which is a great phrase. I want to start more sentences with in terms of the shenanigans. But yeah, I mean, I try in the report to kind of walk through just trying to brainstorm what each one would be in terms of, okay, so you can introduce early before you've gotten a report from Congress. You can introduce a joint resolution. Does that open up any strategic shenaniganery? And the answer seems to me, I have a lot of trouble thinking of any possible way you could, right? I mean, because every other step of the statute is tied to the report itself, no consequence flows from the date on which you introduce. So you can do it earlier. That may stretch the window with which the committee has the joint resolution in front of them, but they're not holding the process up, and it's just hard to think how that actually implicates anything. And so it really does just come down to that back end piece where you would have, again, Congress can always just use regular legislation to overturn a rule. So that process just exists all the time, right? And so the only thing that would change with this is that 802F, I believe it is, provision for reconciliation, where when Chamber 1 passes a resolution, you would have a procedure specified for the way it's taken up in the second chamber that is not specified for your default legislation, and that would become available. And in terms of the shenanigans you get from that, it really is just the question of how much of a payoff does anyone feel that really is. And maybe it's a lot, but I'm pretty skeptical of that, because it seems that the real bump is that you get freed of Senate, veto gates, and those, you're back in the world of having those, because you don't get the benefits under 802, D or E here. Or excuse me, C or D. So, but that is just a value judgment of how much you think that specific piece of the puzzle of things, of what happens when a chamber already passed something, unlocks new opportunities that you don't like. And again, to underscore, that already is available all the time, as long as you drop a joint resolution in the hopper during the introduction window. As long as you do that, this resolution process is available as long as that joint resolution is available. It's just about whether you drop it in the hopper in time or not. So that's the piece. It already exists open-ended, provided introduction. But that's the thing that you're thinking about, whether you see gamesmanship happening around.
Thanks, Jesse. And then the question about sort of further vetting with other experts in addition to yourself on Congress. Richard Julian suggested Sarah Binder and Molly Reynolds. I don't know. I could assume that the draft recommendation, I think, is public. So I don't know. I certainly would welcome further information. I don't know whether you did consult with those people or others like them.
I don't know how much I should disclose about who I have and haven't consulted with on this project. Suffice to say, I have talked to scholars and experts in this field about this report. This was not developed in a vacuum. I think more feedback is always better, and I would be happy to hear what anybody that the committee wants to reach out to has to say about it. So I should probably, I assume, punt on the question of specific people, but I think I've consulted with a lot of folks. I would encourage you to consult with more. I'd always comment. Yeah.
So let me see if there's any objection to kind of furthering Bridget's suggestion, which would be, I think, asking ACUS staff to reach out to maybe those two people just to see, on recommendation 5 and maybe some of the others, just to see if they also spot any other issues that they might want to raise. Is that I'm not deep enough in my ACUS experience to know whether that's a done thing.
Oh, sorry, Kevin. Are you finished? Or
yeah.
Perfect. Yeah. So I'm happy to jump in. So yeah, certainly we're open to do that. I mean, I wouldn't want to, hold the project up at all. I mean, we're happy to sort of send out those emails, and I feel like, as Jesse indicated, I feel like we've got a solid, basis, empirical basis, but I certainly am not opposed to doing that additional outreach. We're happy to send those emails out, and hopefully, prior to the next committee meeting, if we've heard back from them, I think that's we're certainly open to that.
Okay, thanks, Reeve. Hearing no objections, that'd be great. And certainly not to question at all. We've got a wonderful basis in the report, and we wouldn't want to have a sense of precedent when a consultant does a absolutely fabulous report, then we kind of reach outside of it. But I think there's something useful here. We've got about 15 minutes left, and I wonder whether we could finish off our discussion of, or start our discussion at least of recommendation 6. And then I guess maybe before we do that, let me just see if there's, I think we've discussed the language that Bill Funk recommended in 5, and I didn't hear any objection to that after some discussion, seemed to be clarifying. So unless I hear otherwise, we treat that as accepted, and maybe we could see if we can sneak under the last quarter hour recommendation 6. Maybe I'll revert to a little oral reading just to kind of make sure we're all here. Congress should review and, where appropriate, enact existing parliamentarian interpretations that bear on calculating deadlines under the CRA. If Congress does not enact those interpretations, it should ensure that they are published in a manner that is accessible to the public. And maybe we could start with okay, Bill Funk.
And my question was whether or not enact meant enact as statute or enact as rules of the houses, or would either be okay? That's my question.
Sounds like a good question. Jesse, did you have a sense of where we were talking about legislative enactment or rules enactment?
Yeah, I think the idea was to enact it into statute, at least some subset here of the parliamentarian interpretations, because the rules, this is the whole problem, is that they already, I mean, I guess you could enact it as formal rules insofar as it's being done on a rulemaking basis. Right now, that is not necessarily leading to them being in any publicly available place. So I guess if you wanted to fold them into the formal chamber rules, that would fall under this sort of non-statutory publication recommendation. But the idea was, the cleanest way is for just for this to be visible on the face of the statute, particularly because a lot of these interpretations aren't just gap filling; they are leading to things that seem borderline contrary to the face of the statute.
Great. Kriti,
Yeah, I think my question is just clarifying. I'm just wondering whether the intent of this proposal is to indicate that we are indifferent to the content of these interpretations, because I took from the report that we know what some of them are. We're not clear on what the full universe is, and the position is just anything that is a rule that Congress is currently operating under should either be law or clearly published somewhere else. And I'm just wondering if that's right to read it that way.
Yeah, I think that it wasn't necessarily meant to be, it was kind of staying within the realm I mentioned before of technical recommendations, of saying, look, even if the goal here is to stay out of substantive changes to the law, but merely to simplify and clarify its operations. It was just sort of remarked in the interviews for this. Someone said, just if any of this stuff was down on paper somewhere people could access, it would make our lives a whole lot easier. And so that's the intuition, is that, okay, even if you're not going to tinker with any of this, and I think functionally this thing goes over to Congress and they're going to decide whether they want to or not. But the recommendation was putting some subset of this just on the face of the law would help all interested parties.
Thanks, Jesse. So Bridget Dooling, and then Bill Funk, is that a new hand? Okay, so Bridget Dooling first.
Hey, thanks. Jesse, I wonder if you can speak to the culture and norms around parliamentarian interpretations, and whether, the closest analogy I can think is like an OLC opinion, where there's sometimes great sensitivity about when and how to release those. Are there norms around how the parliamentarian, feels about releasing these publicly, or anything that we should know in terms of context for what this looks like, and also what these actually look like? I'm envisioning letters, but I'm hoping you can just kind of flesh it out a little bit for me, what these things actually look like.
Right. Well, insofar as they're taking the primary recommendation, which is to make it statutory, it looks like it looks like Section 802 of the CRA, right? I mean, you have this sort of steady use of rulemaking power within statutes, that Congress does put some of its rules there. In terms of the sensitivities around making them public, they do try to publish them regularly. The Senate parliamentarian, as I mentioned, is not for quite a while. Perhaps that is a resource issue. Perhaps that is some sort of desire to hold them more closely. But they do, periodically publish these things. So it's not sort of like you're asking for something to be made public that has been historically kept secret or something like that. They will release kind of bit by bit interpretation. Sometimes the Senate parliamentarian just did one with us, I believe, by like a letter type format. So it can vary in terms of how it is released based on how expeditiously they're trying to do it. But this version of sort of rules in statute, you do see, and that is what section 802, for example, of the CRA is.
Thanks, Jesse. So Bill Funk and then Michael Hertz.
I'd like to make a sort of formal recommendation to, with respect to my earlier question. As I understood Jesse's statement, it was they could do this either by formal rule or by statute, and it would have the same effect and be equally good. So I would like to add after the CRA in the first sentence, put comma, either as statutory law or as formal rules of the houses. And then in the next sentence, if Congress does not enact those interpretations as statutory law, that's all I need to do.
Okay, thanks, thanks, Bill. I don't know, Michael probably wasn't thinking about the amendment that Bill just made, but you're next here. Do you have thoughts on this matter, Michael?
No, I don't. I'll wait until we've discussed Bill's.
Okay, let's talk about these amendments here. Jesse, let me just turn to you first.
Yeah, sure. So I think that certainly would be helpful if you did it even in the rules of the chamber. I think at least some subset of these probably would be especially nice to have on the face of the statute, that I would consider whether at least some smaller universe. I realize that's starting to get more and more in the weeds here, but the ones that are, and this may be a politically delicate thing to say too, but like the ones that are frankly like where the statute is misleading as opposed to just silent, to just have the language of the statute line up with its application, because you are asking for more sophisticated actors if you expect people to go to the statute and then the rules, right? Than if you just make it so whoever shows up can read the face of chapter 8 and understand the operation, and that's the value you would lose by that process of putting them in the rules versus the statutes. But for at least a lot of them, that may be just as effective. And I think either way you do get a lot of benefits. So I think, but that's how I would think about the trade-offs.
Let me just ask a question to Jesse. How much is there a concern about the version of the House rules? If those, or either House rules, do those change that we might? I guess you'd always be looking at the current version, so that wouldn't be. I was just trying to think of whether there's other complexities that would involve, there. Doesn't sound like it. So there, I withdraw my query.
No, I mean that's part of it. So the Senate considers itself to have standing rules because it's theoretically a continuous body, and so it has standing rules that stay the same unless you change them. The House, because it resets membership every Congress, is theoretically a new body that enacts its rules anew, and so you don't get the permanence benefit there necessarily. Now, obviously, as practice, they tend to carry over the same rules over and over, but you're getting more like an appropriations type statutory benefit than another area of law type statutory benefit in that case.
Okay, good. Anyone else want to? I guess there's some clarity and transparency benefit to having the statute, as Jesse mentioned. And there's, I guess, a little flexibility for Congress of allowing it to be in statutory law or in the formal rules of the House. Anyone else want to jump on that thought or comment on this amendment? Yeah, Kirti Gatla?
Yeah, I guess it would be helpful, I think, if it's not a huge ask, to know between now and the next session which of the interpretations Jesse thinks would be more appropriate for statute, like if they're related to deadlines that the public normally, needs to understand how this works versus something more internal, just to know if it would be too intricate to put that in the recommendation or not.
I think that would be, is that something you can do, Jesse? I think it'd be helpful if you could.
Yeah, absolutely.
Yeah. And maybe that would be communicated either in a comment box on the revised recommendation or I think that's probably the easiest place to have that in. I don't know whether we're kind of coming down towards the end of our time here. I see Bill and Michael's hands are up, and I also wonder whether we should, whether we're ready to resolve this. So let me just turn to Bill. I think it's a new hand from Bill. Yeah.
Yeah, I just wanted to say, I think it's a good idea what Fury suggested, that we have some look at what Jesse thought would be important to be in statute as opposed to a rule. But the reason I originally suggested this is from my experience serving in Congress as a staff person, it was my sense that it was easier to change the rules than it was to introduce a bill and get it passed by statute. And therefore, giving this as a possible way would make it more likely, perhaps, of getting enacted at all, as opposed to just not enacted. So that's really the reason, the justification for what I suggest.
Thanks, Bill. One other thought on that would be, as in some of the other recommendations, it could be phrased as, we could leave this as a recommendation to enact in statute and then have a subsidiary. If you don't do this, you could do it in a, and that might, I don't know what others think of that. That's elsewhere in the statute. I guess we do have a subsidiary provision here as being highlighted helpfully by Mark. So let me see, Michael Hertz, do you want to, I see your hand still up, and it's maybe the other hand.
I mean, it's a separate point. It's a brief point. I only want to raise it if we're done with Bill's.
Yeah. So let's see here. We have a suggestion to get a little more information about where it would be appropriate or not, where it's particularly appropriate to have these interpretations public or in the statute. And then we also have this giving a little bit more of an out. Let me just ask for some advice, which is, do you all feel ready to vote on Bill's recommendation, or should we kind of hold this, since we're not, I don't think we're going to want some more information on the recommendation as a whole later, whether we can kind of hold it out and see if that informs our consideration for later. I guess maybe I'm inclined towards the latter. Is that okay, Bill?
I support putting it off and getting more information. And I also support the idea of doing your alternative way rather than my formulation of it.
Okay, so we'll maybe think about that a little bit with some ACUS staff about, there is a fallback in here, but whether we could kind of tier the fallbacks in a way that would be sensible. So I'm conscious that we've had a long and productive meeting, and I want to be really good on keeping to the deadline. So I don't know whether, Michael, is yours the kind of thing that's a very small?
I think so.
Okay, let's hear it.
So sorry, forgive me. I can't resist celebrating Jesse Cross's reference a moment ago to situations where the statute is misleading. I think as administrative lawyers, that's a very powerful and important jurisprudential category. I tripped over the word existing, right? I mean, that's what it is right now. They should look at all the ones existing, but presumably in the future, there'll be new ones. And we shouldn't imply this is a one-time deal. And I thought about various complicated ways that one could refer to future interpretations, but I think it does the trick. Just get rid of the word existing. And then we have it as an ongoing obligation. Whenever there are interpretations, Congress should look at them and think about enacting them and make them public.
Super helpful. Thank you. Let me just, Jesse, do you agree?
Yeah.
Good. Thanks, Michael. And so we're at the end of our time. Let me just remind us before we close that we have our second meeting on November 4th from 3 to 5:30, same time. And we'll then kind of revisit recommendation 6 and go from there. And we'll see whether the meeting takes the full time. So close with thanks to all the ACUS staff who've worked so hard on this, as well as to Jesse. We'll have a chance to thank them again. And I look forward to seeing you in a few days forward. Thanks, everyone.